You're listening to podcasts from the Congressional Internet Caucus Advisory Committee, www.netcaucus.org.
Okay. We're going to get started. Good afternoon. My name is Rachel Stelly, and I'm with the Internet Education Foundation. I want to welcome you to our briefing. An EU court just sank the U.S. digital privacy safe harbor. Must Congress pass an Internet privacy law now? This event is co-hosted by the Congressional Internet Caucus Advisory Committee in cooperation with the Congressional Internet Caucus. The co-chairs of the Internet Caucus are Representatives Bob Goodlatte and Anna Hedges on the House side, and on the Senate side, the co-chairs are Senators John Thune and Patrick Leahy. We thank them for their support of educational events like this. And just a little bit of housekeeping before we get started. The Twitter hashtag for today's event is hashtag EU Safe Harbor, in case you want to tweet or follow along. And all of our Twitter accounts, as long as the panelists' Twitter information is on your program. We also have a few upcoming events, both of which are listed on your program. On October 21st, there will be a happy hour with the Facebook team that will include a brief presentation on Facebook as a platform for social good. And on October 22nd, the second annual Congressional App Challenge will kick off. For more information about how to get your office involved, visit our website or talk to Rhiannon Anderson, who's our Executive Director. I'm now going to turn it over to Mary Ellen Callahan, who's going to moderate today's panel. She is the chair of Jenner & Block's Privacy and Information Governance Practice and is the former Chief Privacy Officer for the Department of Homeland Security.
Thank you very much, Rachel. Thank you all, and thanks for coming. I want to thank my panelists, who I'll briefly introduce. Their information is available on the materials, but from my far right, Damien Levie is the head of the trade section of the Delegation of the European Union to the United States. Adam Schlosser is the director for the Center for Global Regulatory Cooperation International at the U.S. Chamber of Commerce. Gail Slater is the vice president, legal and regulatory policy, the Internet Association. And Amie Stepanovich is U.S. policy manager at Access. I want to thank them all for coming. And first, let's talk about what are we talking about here today, right? We're talking about boats. We're talking about all sorts of sinking. Like, that doesn't sound very good. I'm going to do a little stage setting, and then I'm going to ask my panelists to tell me whether or not I'm right and where we're going in the future. So the safe harbor decision that was decided by the European Court of Justice on October 6, 2015 actually has its origins 20 years earlier. In 1995, the European Union passed a data protection directive, which has rules and regulations and general standards by which EU member states have to adhere to data protection or privacy regulation. There's a prohibition in the directive about allowing the cross-border transfer of personal data, which is very broadly defined, and it pretty much is all electronic information. You cannot have cross-border transfer unless the country to whom you're transferring the information has adequate privacy protections, or alternatively, there's some other sorts of protections. The United States has a sectoral approach to privacy and is not considered to be adequate under the European regime. It wasn't in 1995, and to this day, it is still not considered to have an adequate privacy regime such that wholesale data transfer of personal data can take place. So what's a U.S. company to do? From 1998 to 2000, the U.S. Department of Commerce negotiated with the European Commission and created something called the U.S.-EU Safe Harbor. The U.S.-EU Safe Harbor is a regime, and it basically follows the EU standards, the EU privacy principles. And if companies go and make a public proclamation, I, company, adhere to the U.S.-EU Safe Harbor, they're listed on the Safe Harbor on the Department of Commerce's website, which I believe is currently disabled. But they go and make a promise, and they say that I agree to adhere to these standards. The Federal Trade Commission has the authority to investigate whether or not people have the ability to, whether or not they are actually keeping that promise. And you have to renew that promise every year in a public statement. And the list is about 4,500 companies currently have safe harbor, currently had safe harbor regime. That safe harbor was considered to be an adequate legal process under the European Commission. And there's been some questions, and there have been, throughout from 2000 on, there had been a lot of questions. Is safe harbor sufficient? Is this public promise sufficient? Shouldn't there be stronger EU guidance on this? The European Union's question, the Federal Trade Commission's enforcement of safe harbor, and so on. This kind of came to, and by the way, that deal, the U.S.-EU Safe Harbor deal, is an executive branch decision, so there was no congressional approval over it. It was the U.S. Department of Commerce directly with the European Commission from a legislative perspective for those in the room. In 2013, we had the unauthorized disclosures of June 2013, colloquially known as Snowden. I try to call them the unauthorized disclosures of June 2013 to not personalize this. But after those disclosures, a Austrian law student named Max Schrems went to the Ireland Data Protection Commissioner and said, I think Facebook is violating EU privacy law, even though they are Safe Harbor certified. The Irish DPA said, I can't decide this. The Commission determined that Safe Harbor as a vehicle was an adequate data transfer. The Irish High Court concurred with the Irish Data Protection Authority. It was Schrems then appealed it to the European Court of Justice. The European Court of Justice, first the Advocate General came out with a decision late in September that said that based on the U.S.'s systemic failures in privacy protection, and particularly pointing at the June 2013 disclosures associated with surveillance and wholesale collection of particularly European Union citizen data based off of the reporting, that the Advocate General recommended invalidating Safe Harbor. The European Court of Justice concurred with that decision and invalidated Safe Harbor as of October 6th. It's a long way to get there, but I thought it would be helpful with some framing. So my question to you, Damien, is what did the court decide on, and what's the scope of the European Court of Justice's decision?
Thank you very much for this great summary. The Court of Justice was actually asked by the High Court in Dublin. Actually, it's the first level court that concurred with the DPA, and the High Court did not rule against Schrems, but actually asked the court a question to the Court of Justice, asking whether or not we have this Safe Harbor decision of the Commission of 2000. The Irish Data Protection Authority is telling Mr. Schrems that it doesn't have any duty to investigate his case. Is that right under EU law, or is it the case that despite this decision of 2000 by the Commission that rules on this side or the data privacy principles are equivalent to the rules on the European side, despite this 2000 decision, is it the case that still national data protection authorities have a duty to investigate a claim when a person says, I think my rights have been violated? And the short answer is the court is basically saying, yes, indeed, the national authorities retain a duty to investigate a claim by citizens. And the reason why, the court takes that decision is to say, under EU law, under the European Charter for Fundamental Rights, you need a right of redress. And you need to be, and so the right to privacy or the protection of personal data is a fundamental right in our European Charter, and therefore national authorities have also a duty to enforce compliance of that right, if you want. And so by combining and the directive and the European Charter, the court comes to that conclusion. But to come to that conclusion, the court also says, since Mr. Schrems claims that the Safe Harbor decision of the Commission of 2000 is invalid, and the High Court in Dublin seems to go along with that decision. It's not. I haven't read the Irish Court decision. I only read the European Court of Justice decision. It's kind of interesting to say that the court says, the European Court says, indeed, that Irish Court says, I seem to go along with Mr. Schrems' things. Therefore, I need to investigate this issue of validity or invalidity of the Safe Harbor decision under EU law and primary law, what we call the EU treaties, if you want, which is, in a way, equivalent to your constitution. And so the court looks at the Safe Harbor decision of 2000, Article 1 and then Article 3, and checks whether it considers that the Commission decision remains valid under the law, given what has appeared since then, but also from day one. It looks at how the Safe Harbor arrangement is constructed. It's not a commitment by the United States government. It's a system of self-certification by American companies. And the court says, well, that's okay. It's better that the laws protect the data of private individuals, but still it's okay. And then looks at how it's enforced, how it's organized and enforced, and comes to the conclusion, I don't need to go into the details now, that basically it's not a sufficient protection. And therefore the rights of the citizens, and Mr. Schrems in particular, are not sufficiently protected, and therefore the Commission decision is invalid. I mean, I'm doing a very short summary of that. And so therefore, not only the answer to the Irish court is, yes, you have to tell the Irish Data Protection Authority that you need to investigate this case between Mr. Schrems and Facebook, but also it's ruling erga omnes, and this ruling is binding for everybody within the European Union, including the Commission and all the national data protection authorities. Actually, that decision of 2000 is not valid.
So the decision that the safe harbor is not valid, Amie, I have a question for you. Do you think that this is a decision that's related to surveillance and the unauthorized disclosures of 2013, or is it related to a commercial data privacy decision?
Thank you, Mary Ellen. So I think at its heart we have to say this is a surveillance decision. The impetus for the entire case are the 2013 revelations by Edward Snowden in the Washington Post and in the Guardian about surveillance conducted specifically under Section 702 of the FISA Amendments Act, and more specifically a program called PRISM. So these revelations were what really motivated Max Schrems to take this case, to ask for an investigation, to ask for the Irish National Authority to look into safe harbor. So everything that has come out of that initial decision has come out because of surveillance. And the European Court of Justice's opinion really spends a lot of time looking at surveillance and looking at what the U.S. allows and what standards the U.S. uses in order to judge what surveillance is necessary. So the rest of the world really uses international human rights standards to guide their surveillance programs. They say that surveillance is only appropriate if it is necessary and if it is proportionate. And that's the standard that the EU uses. It's a standard under the ICCPR. It's the International Covenant of Civil and Political Rights, which is a treaty that the U.S. is a party to. And it's the standard actually that was kind of incorporated into safe harbor. There's a huge exception for national security in safe harbor. You can, not comply with safe harbor protections for purposes of national security, but only if that surveillance conducted in the name of national security or law enforcement or public safety is necessary. And so the U.S. really, what the Court of Justice found is that the U.S. practices are not necessary and they do not ensure this very high level of protection, that protection is adequate for our European data. Now, all of that said, the but is coming. It's a surveillance decision, but safe harbor is about commercial data practices. It is primarily a commercial data mechanism. And if you read through the Court of Justice's decision, they actually spend a fair amount of time talking about the inadequacies of safe harbor, about the fact that it's a self-certified mechanism so that there's no independent audits that say if an entity is complying, that there's not enough transparency, that there's not enough accountability. And so while it is a surveillance decision, you have to look at the entirety of the decision and realize that anything that flows out of it also has to meet kind of these deficiencies that the court is identifying in the safe harbor mechanism, also from a commercial perspective. So you really have to kind of dual consider what do we need to do from a surveillance perspective to make sure that the United States law and practice is in line with international standards that the EU thinks it should be in line with, and also what do we have to do from a commercial privacy perspective to make sure that whatever new mechanism comes in, and we will certainly talk about new mechanisms in a bit, actually complies with what the Court of Justice thinks it should comply with. Because now that the Court of Justice has said that national authorities have a ability to review decisions from the European Commission, we can expect that any new mechanism can also go up to the Court of Justice, and they are going to be able to look over this mechanism again. And so you don't want another period of indecision following this where an inadequate mechanism can get struck down a couple years from now.
Adam, I'm going to ask you the same question, which is this a surveillance decision or a commercial privacy decision? And regardless of the answer, if you could let our audience know why transborder data flows are so important and what's the impact of this decision.
Sure. Well, first, I'd like to add a point of clarification about the actual ruling by the Court of Justice. So in the ruling, there was no examination of the commercial practices. It was an examination of the national security side, and it wasn't even based on an investigation. It was based on allegations and PowerPoints and Guardian articles. So it would be very helpful moving forward if the European Court of Justice, if the data protection authorities could conduct a thorough investigation examining the changes to the United States law made since 2013. The discussion in the ruling was based on practices as understood when Safe Harbor was created. And that also brings us to the point that the ruling is a process ruling. So the decision is based on the fact that when Safe Harbor was agreed upon, the Commission, according to the Court, didn't do a thorough investigation of the national security side of how the exception in the Safe Harbor would be used by the United States and what our practices were in the year 2000 when it was agreed upon. So while Safe Harbor was invalidated on process grounds, there is no examination yet on the commercial side. And in fact, the United States, Department of Commerce, FTC, and the Commission have been undergoing a review and an enhancement of Safe Harbor for the past 2 years. So there are some changes in place. There was a report that was put out by the Commission 2 years ago, and both sides of the Atlantic have been working very hard to satisfy the conditions put forth in that report. To your question, whether this was a surveillance or a commercial decision, it was a surveillance decision. So I think that hopefully answers that. The other piece is on the commercial side, the United States has a really strong system of enforcement. If you violate your self-certification, the FTC will carry out an enforcement action. We have 20-year consent decrees. There's nothing like that anywhere else in the world. And the European Commission, when they conduct adequacy determinations, often do not take the enforcement side into account. So while in the United States our commercial privacy practices aren't exactly in line with the European rules on paper, in words, in many areas we go above and beyond what the Europeans do. In fact, some of the other governments that are deemed adequate include Argentina. And I'm sure they have a robust system of enforcement in their own way, but I'm willing to bet in the United States we have stronger privacy practices in actual reality, how it works in practice, not just on paper. But getting to your second question about why is this whole issue important? Why are we here? Why do we care? So data flows are not just social media. It's not just spam and advertising. It's the backbone of the global economy and the transatlantic economy. At the U.S. Chamber, we represent the interests of over 3 million companies in every single sector, every single size. Energy companies, manufacturing, consumer goods, hospitality, plus the internet and technology side. Every company you can think of relies on the internet today. And if you're a global company, you need to be able to transfer data. So in the business-to-consumer area, something very tangible, very easy is credit cards. You travel around the world, you go to Europe, or a European goes here in the United States, they could use their credit card. Data is transferred back to their bank. It says, yes, you have money in your account. It goes to other companies to verify that, yes, you're you, this isn't fraud, and the purchase is satisfied within mere seconds. On the business-to-business side, it's any multinational company that might have employees around the world. It's transferring that employee data globally. It's keeping track of a global customer base. It's, say, for an airplane manufacturing business, it's having data on their engines while the plane is in the sky, being able to troubleshoot and fix problems on the fly, literally. So there's a variety of uses for cross-border data flows, and there's just an unlimited amount of reasons why it is essential to the global economy.
Thank you very much. And we're going to get back to how the Safe Harbor decision is impacting companies a little bit later in the program. But first, Adam raised the question, Amie, about whether or not the decision accurately described that the U.S. surveillance and national security procedures both in 2000, 2013, and today. Could you tell us a little bit what your opinion is?
Sure. So there have been significant changes made in U.S. surveillance practices since 2013. And I think you have to start with recognizing that. Earlier this year, we passed the USA Freedom Act, which Access and most of the other groups that we work with were in support of. We think that that was a tremendous step forward. It's actually the biggest restriction placed on the NSA and surveillance since the 1970s. So it was a huge win. One of the things that didn't really speak to is Section 702 and other sections of the FISA Amendments Act, which is, as I started out saying, what this case was filed under. So it has small steps forward on transparency in regard to those surveillance authorities, but it doesn't really change any of the practices or have any real substantive modifications of those surveillance authorities. So big win, but doesn't touch what we're talking about in this case. The question was, does the case accurately describe surveillance? So actually, the European Court of Justice decision didn't only mention PRISM once, but what they do mention is this like discriminate type of surveillance that is happening in the U.S. And so from a perspective that you're not looking at a specific program, you're looking at 702, you're looking at Executive Order 12333, yes, that is happening. Would I say that it was exactly technically proper in regard to Section 702? There were some inaccuracies as regard to how surveillance is being conducted, but the overall general programs that they are describing in the court order can happen, are happening, and it's because the U.S. doesn't recognize any rights for people outside of the United States. And so this indiscriminate surveillance that they really key into absolutely is going on.
I may take a little bit of a moderator's liberties here, which is the points that Amy's are making is Executive Order 12333, colloquially called 12333, makes a distinction between domestic intelligence and foreign intelligence. And that distinction is that there are different types and more robust types of intelligence gathering activities that can take place outside the United States as well as against foreign citizens. And so the Section 702 that Amie is talking about from the FISA Amendments Act has that theme within it, and Section 702 does talk about foreign residence controls. The Privacy and Civil Liberties Oversight Board did a report on 702, as did the President's Review Group. So I point you to those for more detailed discussions of 702. Gail, I want to ask you a question, which is Damien did a great job of summarizing the decision and what it was talking about. And as Amie pointed out, it talks a lot about, perhaps not wholly accurately, but in Amie's opinion, in broad strokes, consistent with U.S. surveillance activities. Do you think that the court should have looked at EU surveillance and national security issues as well as a comparison?
So thank you. And first of all, I want to thank Tim.
Is your mic on?
Yes.
Okay, cool.
I want to thank Tim Lord and Net Caucus for having me here today. My name is Gail Slater. The lights on. Yep. Okay. Let me just back
just a moment, folks.
Can you hear me now? Okay. So to reiterate, wanted to say thanks to Tim Lord and to the Net Caucus for having me here today. My name is Gail Slater. I'm from the Internet Association. So to answer your question, I think absolutely yes is the short answer. I can explain why. And I think I'd like to invoke a cliche here to explain why I think that the court absolutely should have looked at EU surveillance at the time of the opinion. And the cliche is people in glass houses shouldn't throw stones. So look at, we've talked about this decision, the Schrems decision, and as I see it, it's based on various snapshots. Okay, so one of the snapshots is U.S. surveillance in 2013 at the moment in time that the Snowden revelations happened. Okay, another snapshot is U.S. Commercial privacy enforcement. I think at the moment in time when the first safe harbor was entered into in the year 2000. And so that's the second snapshot. And then they didn't take a third snapshot, and that was a snapshot of EU surveillance through the member state intelligence agencies in 2013, also around the time of the Snowden revelations. And so I think these three snapshots are important because they all go to this question of adequacy. So the Safe Harbors Foundation is a decision taken that the U.S. system of privacy was inadequate in the year 2000 versus the EU system, okay? And then they made some incremental changes, agreed to make incremental changes to the U.S. privacy regime such that they could close the gap between the EU system and the U.S. system. And so that was done back in the year 2000. And then the Schrems decision comes along, and the court says that because of mass surveillance in the U.S., as revealed by Edward Snowden in 2013, the safe harbor was no longer invalid because of this inadequacy. But you have to ask yourself, inadequate compared to what? And so the comparison here, if we're looking both at surveillance and commercial privacy, has to be to EU surveillance. And so we also know from Edward Snowden, also in 2013, that many EU member state intelligence agencies were engaged in mass surveillance of their own citizens at that time. And the list is pretty extensive. My computer just turned off, so I'm going to have to log back in. He did. So the list includes the Germans, the French, the Spanish, the Swedish, and the British intelligence agencies. Ironically, it did not include the Irish intelligence agency. I'm from Ireland, so I can tell you with all candor, I'm not even sure there is an Irish intelligence agency. But this is significant because this is, of course, where the case originated from, the Schrems case that went to the European Court of Justice. So what the Snowden revelations with regard to the EU member states said was that there was extensive mass surveillance going on, also in 2013, of internet traffic and phone traffic of EU citizens. And so what the Guardian did was it revealed documents, particularly a document produced by GCHQ, which is the British intelligence agency, and it was a scorecard across a number of dimensions of their sister intelligence agencies. And just to give you some context here, in my experience, the British are never likely to give the French a compliment unless they really deserve it. And here's what GCHQ had to say about the French. They described the French agency as highly motivated, technically competent partner who have shown great willingness to engage on internet protocol issues and to work with GCHQ and cooperate and share with us. So
that means that France is sharing surveillance information with England. Okay, just want to make sure I got that.
Both internet and telephony data. So I think this is important. I think it's also important that the second snapshot I talked about, which is surveillance in this country post-Snowden revelations and the significant reforms that have been put in place since 2013, were not taken into account by the court. Again, this goes to this adequacy finding. And I think had the court taken into account both EU surveillance and U.S. reforms post-2013, and also the sort of market-based solution to surveillance, which is increased adoption of encryption technologies by Internet Association members, but also by other technology companies. The delta, the inadequacy delta, we'll call it, between the U.S. and the EU systems would, I think, have declined significantly. Would that have changed the court's opinion? I don't know the answer to that question. That's crystal ball gazing within crystal ball gazing. But I do think it's important to have this conversation because I think it's important in terms of finding a solution to this issue that governments see the reality on the ground in both regimes. And then the other snapshot, if I might, that the court didn't take, which I believe would also be should be significant in these future conversations and negotiations around Safe Harbor 2, is the increased and robust commercial privacy enforcement by the Federal Trade Commission in this country. And I think when Mary Ellen, you will testify to this, but when you look back at the year 2000, the FTC was just really finding its legs in its privacy enforcement space. I think it's come on leaps and bounds since then. I think we can say with some confidence that it's probably the leading privacy enforcement agency in the world, and it has a track record that's very significant, and is really something that's left out of this Schrems opinion.
Sure, Adam, and then Damien wants to make a comment thereafter.
So just to underline what Gail said, it's the national security practices on the EU, their federal level, but also their member state level. So there's two pieces, and Damien will explain in more detail, I think, in a second, but the member states have the competency for national security and law enforcement largely in the European Union. So by saying we need to examine the European Union practices, it's their federal level and also below that. That's really important. And one just quick example of how that works in practice. Last year, the Court of Justice reached a decision on a data retention case, first a data retention directive. They said the rules written violated their fundamental right of privacy, much like the outcome of the safe harbor case. However, it is up to the member states to implement that decision. So there was no required way or set way on how the decision is followed. So some states got rid of their retention rules. Some states, such as France, actually expanded it. So that's why it's really important to examine the practices as they stand today on the member state level. And just anecdotally, when we travel internationally, there's several countries where we actually have to get special phones because of security concerns. One of them is France. So it's very interesting, the state of play today.
Damien, turning to you next.
Thank you. I think we are reading too much into the judgment. I think we need to step back and understand what rules the European Court of Justice has to follow in this procedure. It's a procedure in front of the National Court in Ireland, where the High Court has a doubt on the validity of EU law here, the Safe Harbor decision of 2000. And it's only answering a question from the High Court. And it's relying on the facts as explained or summarized in the High Court decision. I would note that no Americans took part in that judicial proceeding in Ireland. Facebook did not participate, nor anyone else. And so that's the reason why the court in Luxembourg is relying on what it hears from the High Court. And it doesn't decide on other grounds. And I think fundamentally, it's about the judges in Luxembourg seeing an Austrian student who doesn't have a right of redress. He wants to have a court listening to his case, basically, and saying, I think my rights are violated. And the decision of the Irish Data Protection Authority was, in a way, denying that right. So I think it's not more than that.
So we're going to talk about redress in a little bit, but I have a follow-up question based off of Gail's and Adam's comment, and this is for you, Damien. So as you pointed out, the European Court of Justice decided that individual member state DPAs have the authority to investigate adequacy or whether or not there's sufficient protections in each of these scenarios. Do those same member state data protection authorities have the oversight authority over member state surveillance and national security issues? As Adam pointed out, national security is actually a member state competency or authority. So I was wondering, do the DPAs have that authority in their own right vis-a-vis their own member states?
Depends. In some countries it's the case, in some countries it's not. But I have no doubt that after this judgment, all the DPAs will review, and government authorities in general will review their own laws and practices to make sure they are complying with the new judgment.
And for the member states, and I think there are a handful of member states that do have oversight authority, DPAs have oversight authority over national security. Have there been any enforcement actions in those scenarios, do you know?
I don't know. You need to check country by country. I cannot answer that question.
Okay. No, that's great. Thank you. So, Adam, Damien was saying that we're reading too much into the judgment. I guess my question is, regardless of what we're reading into the judgment, what's happening on the ground? What are companies doing as a result of the judgment? Could you tell us a little bit about that?
Sure. So from a policy standpoint, it's always fun to read into judgments and speculate and have sessions like this. But the companies that we work with, they have a legal department and a compliance department, and it's their job to make sure that their company follows the law. So they have to read into the judgment and read the tea leaves about what's happening around the rest of Europe in reaction to the judgment. So the first order of business is to just do a data mapping exercise. What type of data do we have that's being transmitted? What were the safe harbor agreements being used for? Because many companies, if they're a large multinational, they have hundreds of vendors. So an example is a hotel company. They have hotels in every single member state, often multiple ones. They have staff there. They have restaurant staff there. They have food that supplies the restaurant. They have reservation lists. So you're looking at hundreds of individual agreements for hundreds of different entities within the one company. So it's a very, very extensive and time-consuming process to figure out, okay, what are we using the Safe Harbor program for now, and then what can we use as a substitute? Some of the suggestions are extremely complex and difficult. One suggestion was binding corporate rules. That could take over $1 million, up to 18 months, And it was over 18 months prior to the decision when there's going to be now hundreds of companies seeking out approval for that. Another mechanism that had been accepted previously was something called model contract clauses. These are, like it sounds, set clauses approved by data protection authorities that companies can use to prove that they're in compliance with the law. Recently, there was one German state data protection authority that said, we may not think these are valid anymore.
It's up to 5 now. 5 German state data protection authorities, so the equivalent of our United States, have said that they're questioning whether any data transfer to the U.S. is sufficient in light of the decision from last week.
And without a thorough investigation, again. So that's something that would be helpful in providing some heft to a decision whichever direction that it goes in. But see, so if you're a company and you're hearing this, what do? You have customers that rely on you. You have employees that rely on you. The decision isn't just about U.S. companies. It's about companies and consumers and end users in Europe, in the United States, and that is something important to consider as we move forward on this issue.
Gail, how is this affecting transborder data flows right now?
So, again, short answer to that question is we're still in the early stages. I think it's fair to say people, including yourself, are absorbing this opinion and counseling clients as quickly as possible and steering in the safest and right direction. In many cases, that's the EU DPAs who are known to have good processes in place with regard to reviewing and giving their approval to these binding corporate rules. And also, as Adam says, people are doing audits. So how is it affecting transborder data flows? I think it's a little bit too soon to say, but what we can say with certainty is that there's great legal uncertainty. And we can also say that this is impacting, we believe, small businesses, medium-sized businesses, more than large companies, which includes the large companies here would include members of the Internet Association. The larger companies could see the writing on the wall, and they were able to take steps and contingency plan for this outcome. And so many of them already have in place binding corporate rules, and they've resorted to model contracts. They also have sophisticated lawyers and the resources to pay for these other instruments. The smaller companies, I think it's fair to say many of them are in a state of disarray, and they don't have the resources to spend $1 million and invest 18 months of man-hours in getting a binding corporate rule through a European DPA. So I think we can say that much. And I think there are also, depending on business models, scenarios where there literally is no alternative to the safe harbor. And so that's not every data transfer, but one data transfer that we've heard about is, for example, there are not model clauses that apply to an EU-based processor of the data transmitting to a non-EU-based sub-processor. So there's an example of where there's like just a gap in the law right there. I'm sure you're being asked questions about that scenario. So what businesses are looking for is obviously legal certainty. They're looking for it quickly. They're turning to the European DPAs, in particular to a group known as the Article 29 Working Party, which is kind of the trade association of European DPAs. And they're looking for that group, they're looking, turning to them for federal guidance. Because right now we have a scenario where you could have 28 different interpretations depending on the DPAs, and then you have, in addition to the 28, a plethora of German DPAs at the local level interpreting the opinion in their own different ways, which would obviously splinter the European data flows before you even get to transatlantic data flows. And so that's a concern. So companies are looking for joined-up guidance from all of the EU DPAs through the Article 29 Working Party, and they're looking for it in a timely way.
Speaking of timely, the Article 29 Working Party is meeting actually right now trying to figure out how to deal with this, what advice to give. Are you going to have a de facto period of transition? Are we going to have a gentleman's agreement? Was another phrase I heard about doing a transition. And as of the time we started this session, the Article 29 Working Party had not come out with guidance yet, but it may come out while we're here. And so as Gail said that's the trade association for the data protection authorities in terms of giving guidance on what they think. Separately, the European Commission has made some general statements in terms of looking at this and trying to figure out what to do. The Secretary of Commerce yesterday in a speech said that, obviously not surprisingly, the Secretary was disappointed with the decision and is looking to work with the Commission to figure out whether Safe Harbor 2 can work. But I guess my question to the panelists, and I'll start with you, Amie, but I'd love to hear from each of the panelists, is what can Congress do?
So one of the things Congress should be looking at is the fact that it was mentioned that the UK, that the EU data retention directive was also struck down recently. And in response to that, the UK passed another data retention law known as DRIPA, the Data Retention Investigatory Powers Act, in order to fill that void. And recently, that also was struck down. So they attempted to pass a law that would fill the void left by an EU court action, and it immediately got, not immediately, but very quickly got struck down. And then they had to, now they're back at the drawing board having to write another data retention provision that they think that they need in order to fill this void again. What I think the U.S. should be trying to avoid is being in that same situation where we take action and then are told that that action was similarly not sufficient and that we have to go back again. So the U.S. Congress should be looking at what it can do now. I know yesterday several members of Congress, both the House and the Senate, sent a letter to the FTC and the Department of Commerce asking for them to enter into a new safe harbor very quickly. I think that may be the wrong path to take, because until the U.S. Congress passes comprehensive surveillance reform, you can count on the EU Court of Justice saying that nothing is going to be adequate enough. And so when USA Freedom Act did pass earlier this year, many members of Congress thought that it was done with surveillance reform. Members of the civil society community were looking ahead to December 2017 when the FISA Amendment Act is set to sunset and saying you're not going to be done, but we don't know if we can weasel in more surveillance reform until this sunset 2 years from now. I think that we shouldn't wait those 2 years. We should be engaging substantively on the FISA Amendments Act right now. We should also be engaging substantively on Executive Order 12333 and trying to figure out what limitations and what protections we can put into place for that authority as well, trying to make sure, again, that we are complying with international standards that every other country that is a signatory to the ICCPR complies with in regards to necessity and proportionality of surveillance. And then the final thing that we should be looking at is trying to, and again, I think there's some necessity in reading the tea leaves here about what the court was saying on the commercial aspect of safe harbor and looking toward potentially a comprehensive privacy law in the United States, something that many civil society groups have been pushing for a very long time, and trying to put into place protections so that the next time the Court of Justice revisits this opinion, they don't strike it down under the consumer protection elements as well. So Congress does have a huge role to play here, I think.
I'm going to turn to Adam and Gail to see if they have any thoughts. Damien, I figure you don't want to give guidance to the U.S. Congress, so I'll give you a pass on that one. But Adam or Gail, other thoughts on how Congress can help this role, particularly given our audience today?
So I would just go back and respond to Amy's position on this by saying it really, I do feel strongly that regardless of, and Damien says that the ECJ looked at what it had in front of it, and these are the, I was just saying that Damien had pointed out that in the case of before the ECJ, there wasn't extensive fact-finding and discovery done, and so that's why they were looking at what I've called these three snapshots, and I believe all three were inaccurate. But I think that it's very, very important, regardless of what the ECJ has done and the court has spoken, that in political conversations and negotiations going forward, we do keep going back to this inadequacy delta and these inaccurate snapshots, because I think what Amie has mapped out is a very tall order for any Congress, and I also don't know it's exactly what is needed when you look at the state of surveillance in the EU, when you look at the robust enforcement by the FTC, and when you look at the not insignificant surveillance reforms since 2013. One thing we do know for sure, because Damien and his colleagues at the EU delegation have said this to us many times, is that Congress can pass the Judicial Redress Act. And that's something that's we understand, going to go to the floor of the House soon. Yes, and so that would be a significant step forward, because what it would do is extend to EU citizens the rights enjoyed by US citizens under the Privacy Act of 1974, and that is a significant step forward, as we understand it, from the EC Commission, but also from the DPAs themselves, and a step forward in the right direction.
Adam?
The Chamber, the Internet Association, several other associations around town and companies all signed a letter recently supporting the Judicial Redress Act and calling for it to come to vote soon. And one piece, as I see it reported in the press all the time, it's not just tech companies, it's not just a technology coalition, it's, again, all businesses, a broad spectrum of businesses. And if we had a bit more time if there was more time to have others sign the letter, I know there's plenty of other companies that would have joined on as well. So it's a big base of companies and associations that support that act. That's one thing that we can do to help answer the concerns of the Europeans. But when it comes to any other changes in Congress, domestic reforms, there's things that we should do for Americans, for ourselves, not just for the Europeans. If it makes sense to look at a privacy bill that maybe simplifies the rules out there and has the right balance between innovation and privacy, that's something that we could do for Americans, not just for Europeans. So I think the immediate step to answer the court's case, the court's ruling, would be the Judicial Redress Act. Anything beyond that is for the United States, I think, and it should be, to borrow a word from my European colleagues, proportional, whatever that might be.
Great, thank you. So both Gail and Adam have mentioned this Judicial Redress Act, and the Judicial Redress Act, as Gail pointed out, would provide all citizens the right to redress in terms under the 1974 Privacy Act. The 1974 Privacy Act is very near and dear to my heart. When I was at Homeland Security, I had to enforce it. And what it was it is about the government's collection and use of personal information, that you have to say what you do, have a record retention policy, and have the ability to provide redress to U.S. citizens and legal permanent residents. So why is that? Why was that carved out? It's a question that my colleagues and I asked all the time, and it could be that we didn't have this transborder data flow that Gail and Adam have spoken so passionately about. It could be that they didn't want to have redress rights for people who were asking for visas to come to the U.S. Could be a whole bunch of different things. And it could be that, when you're thinking about filing cabinets, it's different when you think about the Internet of Things. So the Judicial Redress Act, as proposed, and as Gail said, is moving through the House, would give redress rights to European citizens and basically to foreign entities as long as they, too, had adequate protections. So, Damien, I got a question for you, which is, given that the Judicial Redress Act, as Gail and I have described it, only addresses government collection and use of personal information, and even in the Privacy Act as currently constructed, there's an exception for national security, does the Judicial Redress Act solve this problem?
Well, I think we all agree that the current situation where we are in is a situation of severe legal uncertainty. And the Judicial Redress Act would be a big step forward to reducing that legal uncertainty. And so from a European perspective, we've been saying this for 2 years. Officially,
Damien, you've been saying this for 6 years since I was negotiating with the European Commission.
And so I think it would be very important to take this decision. More broadly, I wanted to just intervene and say what government is doing on the European side, or what the Commission is doing. First of all, the system is so that it's for national authorities to enforce the directive, and they meet. It's not a trade association; it's actually a group of government officials representing sovereign states that meet, small difference. And the European Commission is there also to help them come to a single point of view. That's what they've been doing last week, yesterday, and today. And everybody realized that we need to give guidance to companies, but also reassure citizens on what's going on with their data. So that's the number one priority, but it may take a while. I think people need to be a bit patient. And also, don't forget that 3 years ago we proposed to fundamentally overhaul our whole regime, to have a much better regime with less divergences of applications. There will be a single rule book. And so we really hope that Council and Parliament, our legislators, will adopt these rules as soon as possible. Thank you.
Amie, do you think the Judicial Redress Act helps solve this problem?
So we absolutely support the Judicial Redress Act, but I it's an incremental step forward. And I want to be very clear. It's a small step forward. It does give, and not necessarily EU citizens, it gives certain countries who are certified by U.S. authorities, so those countries are not named. It's not necessarily countries in the EU or only countries in the EU. Certain rights under the Privacy Act. But again, as Mary Ellen pointed out, there are huge exceptions to it. And many of the programs that we're talking about here aren't going to be covered by judicial redress. And I would add that at least in the Senate, it has been proposed as an amendment to the Cybersecurity Information Sharing Act, which many civil society groups, both in the U.S. and abroad, have outright opposed because it creates huge new surveillance loopholes for more personal information to go to the government, which I think actually runs directly contrary to the court opinion that we're looking at now. So attaching a law that gives a small incremental step forward in name of rights to a bill that actually takes a huge step backward is a net loss.
Adam, I was wondering if you thought, Damien's been focusing on this redress issue. It is something I heard when I was talking to the Europeans when I was at Homeland Security. Is redress the panacea for these transborder data flows from your perspective on the commercial side?
So, as everyone said, it's a step in the right direction, but at this point it's unclear what a panacea would look like to the European side. Again, it would be extremely helpful if there was some sort of self-examination done to see what are the current rights, not just on paper but in practice, at the European Union level and at the member state level, because the United States should provide, or should only be asked to provide equivalent rights to those of the Europeans. We shouldn't be asked to go above and beyond what is actually the practice on the ground over there. And just real quick, on the Cyber Information Sharing Act, something that we support, we think it's very useful in helping deter bad actors. We don't see it as, or the act is not a loophole for more surveillance. It's the case where businesses and other entities can share information with those who deter the bad actors. It's not intended to provide access to more information, but to instead stop. So if there's a breach in one area, companies and those in charge of information security can work together to stop the same breach from happening again.
So I'm going to ask the panel to kind of look in their crystal ball, do a little gazing, and talk about what's next for Safe Harbor itself. There's this Safe Harbor 2.0 that, as Adam said, is being negotiated between the Department of Commerce and the European Commission. Is that dead on arrival? Is that have new life? What do we think is going to go on with that? And what about the U.S.-EU relationship? Kind of where are we thinking we're going with this? And I'd ask you to think both short-term, right? What's going to happen as we all kind of work out this legal uncertainty, I think was Damien's phrase. And then secondly, kind of a medium term, what do we think the relationship should trend towards in the future? And I think I'll start with Amie closest to me and then work down the line, please.
So again, I don't know if any new mechanism is going to work in lieu of comprehensive surveillance reform. I just don't know if we can find a mechanism that complies with this court's opinion in lieu of changing the standard under which the United States conducts surveillance. And I absolutely agree with Gail. There's a problem with surveillance in the EU. There's a problem with surveillance around the world. There's just a problem with surveillance. Every country tries to get as much authority as they possibly can in order to conduct it, and we need to start looking seriously and holistically at all of these countries' practices and pulling it back. But right now we need to look at the United States practices because that's what's standing in the way of a new mechanism. Access has supported the model contract clauses that were mentioned earlier, but we call it model contract clauses plus because we think that they also need to include more robust mechanisms for transparency and for data security in order to protect against unauthorized access to data. Such as what's happening, for example, when the NSA was tapping into the backbone between Google or Yahoo data centers. We think that's not necessarily a good thing for surveillance agencies to be doing, and so we think that data needs to be protected a little bit more robustly. So we're looking forward to engaging more thoroughly, at least in the short term, on that as a new mechanism, and then looking longer term at how to engage on protecting privacy from a very holistic point of view.
Just a question, I think a point. The model contracts as currently proposed by the Commission can't be edited. So I think Amy's comments about model contracts plus would have to get folded into any sort of revisions on the European Commission side. And it is a pretty frustrating contract, if I can have a little discretion to say that. And it's very rigid in terms of the opportunities. Gail, what do you think's next for Safe Harbor and for this transatlantic relationship?
So, first of all, I have to say, just for the record, the Internet Association supports surveillance reform, but we're also aware that, Congress has a lot on its plate, and so we have to be realistic in this context. The other thing I'd say about the relationship with the EU, so I don't know, as some elder statesmen used to say, the problem with the EU is like there's no one phone line. Who are you going to pick up the phone to talk to the EU? And in this scenario, we have many different stakeholders within the EU. I think in talking to the Commission, Damien's representing the Commission, he can speak for them. I think there's a sense in which the Commission wants to do the right thing here. Their decision was invalidated. They have egg on their face, and they want to try and turn this around. They have been negotiating in good faith with the Commerce Department here. They were close to signing Safer Harbor 2.0. Let's hope that comes to pass soon, but I know that people within the Commission first have to look at this opinion and take a close look at it and decide what the new parameters they are operating under are. But we also have a Parliament that's very vocal, depending on where you go in the EU Parliament on this issue. That's a constraint on the Commission. The Commission has to be mindful of the Parliament. And then we have the DPAs, of which we now know there are 28 plus 15 in Germany. And so they're all going to have to want to say something about the Safer Harbor 2.0. And that's these are all checks and balances that the EC Commission has to be mindful of going forward. And so that's the EU. That's a lot of different stakeholders at place. And I don't pretend to speak for any of them, but they are all important voices. So in the meantime, I've said it already, I can't say it often enough, we're looking to the EU DPAs, working through their trade association, the Article 29 Working Party, to issue guidance that's helpful to businesses. Businesses who signed up for the Safe Harbor, there are 4,500 of them, did so in good faith. They complied with Safe Harbor for the most part. If they didn't, the FTC went after them. There was backstop enforcement. And so they're now looking at this legal vacuum where they really don't feel they've done anything wrong. Perhaps the government did, but, they need guidance.
Adam, what do you think? What's next?
So the relationship between the United States and the European Union is just too important. We transfer 15 terabytes of information a second. It's a gigantic number. We have literally trillions of investment flows going back and forth. And the Safe Harbor decision goes beyond just the one program. If we can't share information, if we can't carry on and monitor our investments, that is a gigantic loss, not just transatlantically, but around the globe. I mean, to paraphrase or to quote Vice President Joe Biden, it's a BFD, this whole situation. I mean, it's really important that...
What does that spell, Adam?
Big friendly discussion. So it's really important that the governments on both sides of the Atlantic get together and work on finding a solution quickly, not delaying so there's so much uncertainty. We need to preserve the relationship going forward. And what we need is responsible governments having a conversation to build connections, not to tear them down. The Senate Commerce Committee sent a letter urging quick action. I'd like to see more in the Congress getting involved, talking to their counterparts on the other side of the Atlantic, but just overall really encouraging a swift resolution to the issue at hand.
Great, thank you. And Damien,
thank you.
What do you think is next?
Well, what's next? I hope here is the Judicial Redress Act is passed, and together we are working on a new Safe Harbor arrangement, taking into account what the court has said, and nobody has an interest in having a new Safe Harbor 2.0 that is struck down a couple of months' time. So we need to take a deep breath and make sure that the new arrangement is as solid as we can. Thank you.
Great. With that said, we're at the top of the hour. I want to thank my panelists for an excellent discussion, and I want to thank all of you. Thanks. Have a good night. Bye.